Industrial Dispute Act 1947. When you open this act, you feel like it is a small act. Yes, it originally had 7 chapters along with 40 sections, but however, later there were several amendments which added 3 more chapters along with 39 sections. In a way, we can say there are about 10 chapters along with 79 sections. But the beauty of this act is every single word of this act have a kind of case laws. Now that's the beauty of Industrial Dispute Act. I thought of bringing all of them in one slide. Initially, I felt it is not possible because everything in this law is very important provision. But then I thought I can give a skeleton of this entire act in one slide, and here is my effort on the same. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and let us try see the important provisions related to ID Act in a single slide. 2-3 conditions. 1. I am not going to take the name of any section. 2. I am not getting into detail on any individual provision, and then I am also not bringing in any kind of case laws here. This is a kind of structure that one should know while he starts studying on ID Act. With that intention, I have made this. Hope you are going to like this, and if you like, send a lot of messages to me on the same. With that, I am taking you to the only slide. This is the slide. Here I have brought all the important provisions related to Industrial Dispute Act. When I say Industrial Dispute Act, there are two important terms. The first one is industry, second one is dispute. Now we need to understand what is industry and what is dispute, and that has been very clearly mentioned in the law. What is industry? It is a systematic activity which is carried over by the cooperation between the employer and employee for the supply and distribution of goods and services for the human wants of human being. Now that is the definition for industry, and on industry itself we have hell lot of case laws in India. So that is an independent presentation which is already available in my playlist. Then comes dispute. Now when we say dispute, there should be 2 or more people. So among whom such dispute can take place. It can be between employer and employer, or employer and workman, or you can also call as employee, and then employee and employee. So these are the 3 different types of dispute that we see under Industrial Dispute Act. I repeat, employers and employers, employers and employee, and employee and employee. If there is a dispute among these categories, then what can be the reasons for such dispute? That is also very clearly spelled out in the law by saying the reasons can be connected with the employment or non-employment, or the terms of employment, or the working conditions. Now if you ask me to make it easy, the issues can be related to wages, bonus, profit sharing, gratuity, or any other allowances, or the service conditions like hours of work, leave with wages, holidays, etc. Likewise, it can also be related to discipline, retrenchment, dismissal, closure, etc. When we are discussing about the disputes between the employers and employers, or the employers and employee, or the employee versus employee, these disputes can have 3 different forms. One, individual disputes, the other one, collective disputes, or the third one, deemed industrial dispute, which are also discussed in this particular act. Now we know what is industry, then we also understood what is dispute. Now we know between whom such dispute can take place and what are the reasons for such dispute. Now once the dispute has taken place, there will be consequences, right? And exactly those consequences are in the black box. Now the consequences can be created by the employer or from employee. Now what are the consequences that are created by employer? He may transfer his employee or the industry, or he might dismiss his employee, or he can do demotions of his employee, or there can be retrenchment, layoff, lockout or closure. Now, what are the consequences that can arise from employee? They can go for a strike or they can create disruption. When I am saying strike, there are many different strikes which are discussed here, like go slow, hunger, stay in, pen down, tool down, sit down, sympathetic and work to rule strikes. These are the different types of strikes available, and there are a lot of case laws to discuss whether they are strike or not. For example, on go slow also there is a case law which discusses whether go slow is a strike or not. All these case laws I will discuss when we are actually discussing on individual aspects, like strike is an individual topic, likewise retrenchment, layoff, lockout, closure, all of these are very important aspects and we are going to see presentation on them, and when we are discussing on them we will definitely discuss on the case laws also. Now, I have explained what are the consequences that can be created by the employer because of the dispute or the employee. Now, we can also divide these consequences into two different categories. One, the legal consequences. The other one is illegal consequences. If there are any legal consequences, like there is a legal strike or there is a legal lockout or there is a legal closure, all of this can be sorted out with the dispute resolution system, where we are discussing about works committee, conciliation officers, boards of conciliation, court of enquiry, labor courts, tribunal, national tribunals, all of this. On the other hand, if it is going illegally, like illegal strike or illegal lockout or illegal layoff or illegal closure whatsoever, either it may have created by the employer or by employee, they will have punishment. Like for example, if it is an illegal lockout, the employer has to pay back wages. Likewise, if it is an illegal strike, the employee will have wage loss. And there are other punishment also available like fine, imprisonment, everything is available under ID Act also for all the illegal acts done by maybe the employer or the employer. Now, when we are discussing about the legal methods, I told there are dispute resolution system available, and the methods used there are negotiation, conciliation or arbitration. Now, we are discussing so much about ID Act. Why? What is the benefit of having ID Act? That is my conclusive box, which is in yellow color. It is beneficial to the employee for his safety and security to his job and wages. Likewise, it also protects the employer because there is a safety to the industry. Nobody can just go like that on strike on one beautiful morning. They cannot do that. There is certain legal provisions available for a legal strike also. That way it protects the employer also, and overall it secures our community. By that, the state is also safe. When I am saying state in legal language, it is our country. So overall, this act protects all the industry. By that way, it protects both the employees as well as employers. By that way, it protects our community. There is peace and harmony available. And finally, it protects our state. That is why we need to study ID Act. As I have already told in my introduction, every single term that I have brought here in this slide is an independent topic. Like if you ask me industry, that itself has a lot of case laws. On dispute, there are multiple number of case laws. And who is employee or who is employer, what is individual dispute, what is collective dispute, what is transfer, what is layoff, what is lockout, closure, strike, disruption, the different forms of strikes and the dispute resolution system, all of these are independent topics, and I am going to handle them in a very structured way in my future videos along with case laws. I repeat, this is not the entire law. This is just a skeleton of ID Act, and in my next presentation I am going to give the entire details of the 10 chapters that are available, including the amendment chapters, along with 79 sections, that is original 40 sections along with 39 amendment sections. overall the 10 chapters along with 79 sections. I am going to give complete structure of that in next video. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.